Hey everyone, welcome to our presentation today called Know Your Lingo. We are so glad that you are here. Just a reminder that this meeting is being recorded. This recording is the exclusive property of Real Estate Closing Path. All video files and commentary shared during this session belong to RECP and may be used in future trainings or marketing promotions. Our intention is to represent you and RECP in the very best light. And if you're new here, we are the third branch in a suite of organizations owned by one woman named Marianne Harris. She started in the industry over 20 years ago with Positively Balanced, which provides third-party escrow account reconciliation services. And then in 2020, she launched Positively Closed, which provides remote closing support solutions. And then we are Real Estate Closing Path. We are the training branch in all aspects of the closing process. A little bit about who we are. We invite you to follow us on the various social media channels. We're on YouTube, LinkedIn, Facebook, TikTok, Instagram, wherever you like to hang out and network professionally. We invite you to connect with us there. Currently, we offer 9 different workshops that we do virtually. They're each 3 hours, and we're very proud to say that these are all accredited currently in Georgia and Florida. We can also customize any curriculum to meet your specific firm or organizational needs. And then we can also provide any of these as a lunch and learn. If you're in the Metro Atlanta area, we're happy to do that in person. If you are further away, then we can do this virtually as well. My name is Janis. I'm the Executive Director here at Real Estate Closing Path. Full disclosure, I have never been a closer. In fact, I like to say that I was Sandi's very first student and I knew nothing about the industry. My background is in education. And so I brought some structure around some curriculum development. Again, creating the 9 different workshops. We do the monthly LinkedIn Lives. We've been working on accreditation and we'll continue to expand to other states in the future. And I help with onboarding students and networking with guest speakers and other leaders in the industry. And again, I've really enjoyed my role and again, have really learned so much from Sandi. Sandi is the lead educator here at RECP. She brings over 40 years of experience in mortgage and real estate settlement. She's been in large firms, small firms, and engaged in all aspects of the closing process. It is her wit and wisdom and experience that you'll be benefiting from today. And again, she's really been in charge of all the curriculum development, all of the training. And again, we just really value and appreciate what she brings to RECP. And just for fun, a little humor here as we get started, you know, how do people see the home that you live in? What's the reality versus the projected perspective here? How you view it. To the right of that, how your buyer views it. Your lender, it's getting smaller. Your appraiser, until the big one at the end, your tax assessor, right? All different perspectives looking at one unit. Well, interested to know the perspectives here on these different categories. So again, if you're new to the industry, it has its own set of lingo. There are different, vocabulary and acronyms that are unique to this industry. And so Sandi's going to be talking about those here today. We're going to look at firm documents, contract and realtor lingo, acronyms associated with title and the lender. I know it says Cahoots here on the slide, but we don't anticipate playing Cahoots here today. But again, I hope you'll still enjoy this presentation. And so I'm going to let Sandi share, first of all, talk to us about the different firm documents.
Okay, before we actually get into that, I want to say when we were working together to compile the curriculum, we realized that we were speaking in a language that somebody outside the industry might not know. And even within the industry, we in the settlement office might not understand all the things the lender was referring to, or that the title examiner was referring to. So we became aware that it was beneficial to prepare a list of acronyms so that we all are on the same page. So I mentioned to Janis that I watched a documentary about J.R.R. Tolkien last night, and it talked about how he created all these languages. And if you didn't know, you wouldn't know how to speak Elvish. So we're teaching you how to speak closing. So this is sort of the way it goes. And when I say firm, in Georgia, that means the attorney's office, the settlement office. In other states, that could be the title company, whoever is performing the closing and preparing the legal documents outside of the lender. So some of these documents are things that we prepare ourselves. The acronyms for AKA, FKA, and NKA all are alternative names, and they are interchangeable. It's purely a preference of the preparer. AKA, as I'm sure most of you know, is also known as. FKA is formerly known as, and NKA is now known as. So you can use any of them interchangeably. You just have to be sure that the names are in the right order. For example, you have to convey title the same way you took title. But if in the meantime your name changes, you know, I bought my house as Sandra H. Kelly. And then down the road, I'm conveying title, but I'm not Kelly anymore. So I could say Sandra H. Kelly, NKA, now known as Sandra H. Donaldson, or AKA, you can do it that way. Or I could say Sandra H. Donaldson, FKA, formerly known as Sandra H. Kelly. So you can do it either way is correct. It's just you got to get the names in the right order. Otherwise, you are you're gonna get them mixed up and record backwards. A power of attorney, POA, we say that a lot. If somebody is signing on behalf of one of the authorized signers, whether it's the buyer or the seller or whomever, there is a document that gives that individual signing authority. And so we have to prepare that. And, you know, interestingly, sellers in particular think that's just an easy thing to do. I'm in Spain. I need you to prepare a power of attorney for me. No problem, but you have to sign it in Spain. And so, you know, there are certainly logistics that are involved in preparing that. But for our purposes here, just know that that means giving signing authority to another party.
Great, that's really interesting. And just for those watching, we're going to have a slide here that now shows the different definition or the different words here that these acronyms stand for. So I hope that that's helpful. Sandi, I know you said that all of these are acceptable, AKA, FKA, NKA. You feel like there's one that's more commonly used than the other?
Almost everybody uses AKA just because it's universal. You know, personally, I like NKA. I like now known as, because this is what my name used to be. This is what it is now. You know, I like that. If I'm preparing it, that's what I'm going to do. But again, when I was the closer for an attorney, I prepared it the way they told me to prepare it, right? You know, so it purely is preference, but I think you see AKA the most.
Okay, good to know. All right, a few more here.
Right. Okay. And both of these have to do with the manner of title, how I hold title. JTWROS, joint tenants with right of survivorship. We see this most often with a married couple. If you hold title, joint tenants with right of survivorship, each of you owns 100% of the property. If one of you passes away, that interest is automatically conveyed to another person. It does not require additional documentation, does not require probate. All you have to do is produce a death certificate. It would be true if there were more than 2 people on title. If me and my 3 siblings owned a property, joint tenants with right of survivorship, and one of them passes away, then the other 3 own it. So it doesn't have to be a married couple, but it happens very commonly when that is the case. TIC is tenants in common, which is the opposite of that. If you have individuals who are not owning it right of survivorship, tenants in common means each title holder has an equal interest in the property. So if there were 2 of you, you would each own 50. If there were 4 of you, you each own 25. There's 5 of you, you each own 20. So if I owned property with my 3 siblings and we each own 25 and one of them passes away, what happens is it doesn't go to the other person. If a title holder in a tenant in common title passes away, their interest in the property is conveyed to their heirs. So if it were me and my siblings and I pass away, my interest is conveyed to my heirs. And this does require probate because it doesn't automatically convey. Right of survivorship automatically conveys upon one of the title holders' death, but tenants in common does not.
Gotcha. Good distinction there. And again, a slide with it all spelled out for everyone. I have a question, Sandy, because I know a lot of first-time home buyers maybe don't really understand, how title works or who should be on the title. Who is the one to inform them? Is that really the attorney's job?
Yeah. The settlement agent is the one that will tell them that. The lender normally in their title request tells us how they're going to take title. So there is some conversation on the lender side. And from my time as a loan originator, I can tell you, I discuss that with people because they don't really understand the difference. You see a lot of tenants in common if you have business partners or friends that are buying a house together, that kind of thing. Now, if you have partners that just aren't married, they still might take it right of survivorship. So it's really up to the title holders, but you most often see tenants in common when there is not a familial relationship.
Gotcha. Okay, good to know. All right, new slide.
Okay, so some of these are things that we don't come across every time, but sometimes. FIRPTA is the Foreign Investment in Real Property Tax Act. So FIRPTA applies to sellers that are not U.S. citizens or not U.S. taxpayers. Basically, the bottom line is if you're going to file a federal tax return, then you are going to include any proceeds of real estate sales as income on your tax returns, and you have tax liability for that. However, if you are a non-citizen and you don't file a federal tax return, the IRS is going to get their money one way or the other. So FIRPTA, a foreign seller has to sign a document at closing whether or not they are a U.S. citizen. And if they are not, the settlement agent is required to collect a percentage of their proceeds to send to the IRS in the form of a tax payment. So that's what FIRPTA is. And starting, I think in 22, there was a FIRPTA clause put into the GAR, Georgia Association of Realtors contract, so that it didn't become a surprise to anybody at the closing table. So that's something to be aware of. And honestly, when a realtor is taking a listing, that's a question to ask your seller. Are you a U.S. citizen? Because we can't tell that from their appearance or their accent or their job or anything about that. We have to ask, are you a U.S. citizen? And we go with what they tell us, because they tell us that. Our E&O is errors and omissions insurance. Attorneys have it, title companies have it, title examiners have it, appraisers have it. And errors and omissions insurance covers any mistakes we make and anything we leave out. And generally, as the settlement agent, when we send our title package to the lender, it includes a copy of the declarations page of our errors and omissions policy, because they want to know that if we've made an error in preparing the title commitment, there is some recourse. So the reason that's important is because generally we keep a copy of that deck page on our desktop and we attach it to our title package when we send it to the lender. Now, GSCCCA is particular to Georgia. This is the Georgia Superior Court Clerks Cooperative Authority. That's a mouthful. Basically, it is an online database. I call it lovingly the deed index. As of 2 days ago when I looked, most of the metro counties are up to date. All the deeds that have been recorded are in this digital index from 1990 forward, because they had to go back. Now everything automatically new is put into the deed index. But the old deeds, their counties are having to go back and do those deeds. So they're only back as far as 1990 now. So anything before that, a title examiner would physically have to go to the courthouse to get, because it may not be in the deed index. As a matter of fact, one of my uncles just asked me to look up the deed from where my grandfather bought a property in 1936. And guess what? It's not in the deed index. Yeah, because Fayette County doesn't go that far back yet. But the GSCCCA also has a lien index, and it has a list of appointed notaries in Georgia. There's a lot of good information in that database. And settlement agents here in Georgia have a subscription to this service so that they are able to retrieve that information.
That's good to know. And so I would assume that other states have something comparable?
Yeah, they have. Yeah, there are other, I mean, certainly now everybody is e-recording. So there are indices for their digital deeds somewhere. Yes, I would imagine other states have something similar.
Okay, good to know. All right, moving on. That's been a really interesting category. Next up, know your lingo around contracts and realtor vocabulary.
And remember, whenever we talk about realtors, we're talking about anything to do with the contract or the transaction from the settlement perspective, because a realtor knows more. They forgot more about what's in the contract than I'll ever know, because that's their responsibility and not ours. Our responsibility is to be able to take out of the contract what we need and to understand from the settlement perspective the things that we need to know on the real estate side. So a FSBO, which is what we call FSBO, for sale by owner, if there are no realtors involved. That type of transaction is a blessing and a curse, because you're taking out some of the people that you have to deal with. So it's a blessing when you don't have any realtors. The curse is you don't have any realtors. So you don't have anybody to help you. You know, you've got buyers and sellers that may not really understand. And part of what the realtors do is communicate the process to their clients. So they're very helpful. I mean, my personal opinion is whatever a realtor costs, they're worth it because they have that relationship with their client, and they're able to, because they represent them, the client trusts their advice more than they trust the advice of other parties, I think. I mentioned just a second ago that GAR is the Georgia Association of Realtors, and that's where we get a lot of our information with regard to requirements from the realtors. And they have some templates for documents. GAR has a contract that we're very familiar with and lots of agents use. It's not required, but it is good to keep up with what the State Realtor Association is doing. MLS is the multiple listing service. where we just looked at a listing this morning. My family has a new listing in MLS, and we took a look at it this morning. So it's what enables realtors from other firms that maybe you work for Keller Williams and somebody from REMAX is looking for a house in a particular neighborhood, so they can zero in on your listing. It's a database for realtor information. They see what's listed, what's pending, what's sold. That's how they get their comparable properties. The appraisers use it to pull their comps. So it's just a database of properties. So it's always good to be able, it's a lot of fun too, to look at.
Is it a database, Sandy, that just includes houses that are for sale, or does it also include houses that have already sold?
Yeah, it does include for sale, pending, and sold. And I can't tell you exactly when the sold drops off, how long it is. But because, for example, the appraiser is supposed to find comps that have sold within a certain period of time, and this is where they get them.
So they're going there. And Sandy, do other states have their own version of the GAR contract? So every single one has
everybody has, again, not required, but yes, as a matter of fact, I have an example of a Florida Association of Realtors and one from Texas. And so, yes, they don't look exactly the same, but they have the same information. So yes, there's not a national standardized thing because every state is its own entity as far as real estate laws are concerned. But they do have their set of documents that work with what their rules are regarding the transaction.
Good. All right, moving on. New slide.
Okay.
Several here.
A lot of these have to do with the HOA, the Homeowners Association. It's interesting. I spoke with my sister this morning who lives in Florida, and she told me that a friend of hers who lives in a condo in Florida just got informed by their HOA that they have a special assessment coming to repair some prior hurricane damage of $100,000 per unit. A special assessment. So your homeowners association basically helps with common areas. When it's a condo, it's the exterior of the property, lawn care, your pool, your tennis courts, those kinds of things. The CAD in Georgia, Community Association Disclosure, is an exhibit to the contract, which gives us information about the HOA. Who's the contact? How much is the HOA? Is there a transfer fee? Is there an initiation fee? That kind of stuff. We get a lot of that information from that exhibit to the contract. The CC&Rs are covenants, conditions, and restrictions. That's the rules to the HOA. We always encourage people that are buying in a development that has a homeowners association to review the CC&Rs before they buy, because we need to look at these rules and see if that's something I can live with, because some of them, you can't leave your trash can on the curb overnight, which is great, because it keeps the uniformity and the nice appearance of the neighborhood. And I lived in a neighborhood one time where you could paint your house any color you wanted as long as it was one of these three, because these were the three that were approved by the HOA. So it imposes some standards on the neighborhood, and some people love that because it ensures that the neighborhood is going to continue to look nice. Your neighbor can't park a tractor trailer on out on the street, or your neighbor can't paint their house purple. I actually had that happen one time. Your neighbor can't paint their house purple, or something like that. So if the restrictions are no problem for you, great. But it's really hard once you get into a neighborhood, you haven't read them, and now you're being fined by the neighborhood for something like that. Some violation that you didn't even know existed, right? The ATAC is the amendment to address concerns. It is a contract amendment in Georgia. After the buyer has had the home inspection, they will submit this amendment to the contract of things that the inspection revealed that they want the seller to repair. So this is a list of repairs that the buyer is asking the seller to do after the home inspection. And then there's some negotiating back and forth. Sometimes the seller says, well, I'll do these three, but I'm not doing these three. And sometimes they'll say, I'll give you $1,000 in lieu of repairs. It depends on how serious they are. They can be anything to a plug's not grounded or a floodlight bulb is out to you got cracks in the basement wall. You know, so it could be anything from very minor to very serious.
Very interesting and very helpful. Thanks for sharing. We've got one more slide in this category. Talk to us about DA and PAC. What is that?
Yep. Also in Georgia, when our realtors submit what is now known as their broker compensation agreement, how much they're going to get paid, then as the settlement agent, I'm going to cut a check for the total commission, $10,000, to Keller Williams. Unless the agent brings me a DA, disbursement authorization, or PAC, pay at close, they're the same document, they're just named different things depending on which firm they come from. But basically it's a breakdown of the commission. It tells me the agent gets this much of it, the brokerage firm gets this much goes to FMLS, they're giving this much to charity. It tells me we become the accountant for the real estate firm, and we break the commission down however they want us to. Sometimes it's 2 or 3 disbursements that come out of that. I've seen as many as 12.
Oh, wow.
So if they don't have this document at closing, then the agent has to take the total commission back to their broker, and their broker breaks it down. It delays the agent getting the money in their hands. Wow. So they like to bring these documents to us so we can pay them directly at the table.
Gotcha. That makes sense. So again, just to clarify, I heard you say that these are almost essentially synonyms, that it's different terminology for essentially the same.
Yeah, they give us the same information, but yes, they're called different things.
All right, good. All right, we are moving on to a new category. Up next is title. What are some of the acronyms that we need to know around title?
Well, title means many things, right? From our closing perspective, title, we're asking for a summary of the ownership history of the property. One of our guest speakers told us it's all about the dirt. It's not about anything above the dirt, not the structure. You know, it's about the land, the ownership history. When the lender says, I need title, what they're telling me is, I want that title commitment, that document. Sometimes they're talking about a title policy, which we write at closing. So title refers to a lot of different things. ALTA is the American Land Title Association. It's a national association with title rules and standards, different guidelines. They also provide some documents. They get together and revise and generate documents. So as of right now, our settlement statement, our closing disclosure is an ALTA form. They came together and prepared, created these documents for us to prepare. Language in our title commitment, we call it the ISAOA language. Many lenders make their big money by selling the loan in the secondary market. A lot of lenders are not loan servicers. When you close your loan, who originated your loan is not who you're going to make your payment to. They sell that loan in the secondary market. The lenders tell us at closing a document, we definitely will sell this loan. We definitely will not sell this loan, or we may sell this loan. Some lenders are originators and servicers, like Wells Fargo, Bank of America. they originate loans, and they service some loans as well. Some servicers are not originators. Aquin Financial, Dublin Mule Mortgage, people pay them, but they are not they are not originators. And so anyway, this ISAOA language, basically when the lender tells us in their title request how they want their name to read in the title documents. Wells Fargo Bank, NA, Wells Fargo Home Lending, Wells Fargo Home Mortgage, however they want their name to read. This ISAOA language says its successors and or assigns. So whoever the originating lender is and whoever they sell it to, because they want to be sure that the title policy that they write covers any successor lenders. So whoever we are and whoever we sell it to. The ATIMA language may or may not be included, but it means as their interests may appear. So if Bank of America originates the loan and they sell it to Wells Fargo, they might sell it to Wells Fargo Lending, Wells Fargo Bank NA, Wells Fargo Home Mortgage. The ATIMA language means however their name reads, whichever entity it is. So whoever we sell it to, whatever their name is. So basically, we're just making sure that the lender it's assurance for them that they'll be able to sell that mortgage down the road because the successor lender is going to be covered by the title policy that we're writing. That's a whole lot of talking, isn't it?
That's a lot of understanding of the acronyms. Okay, good. Next slide.
Okay. A PUD is a planned unit development. If you have an HOA, you live in a PUD. Where, if you've got, Paw that owns 100 acres and he gives all the grandchildren 5 and they build one, that is not a PUD. It wasn't planned out. But when you've got a subdivision that was all planned out ahead of time, then that is a PUD. Now, there can be a PUD that does not have an HOA. I live in one. It was a subdivision that was all planned out, but there are no common areas, so we do not have an HOA. But just bear in mind, a PUD is a planned unit development. Most often, for our purposes, it's a subdivision or a condo complex. A PIN is a parcel identification number. For our purposes, it accompanies the legal description. The PIN and the legal are what most accurately describes a property. Street addresses can change. Unless a property is further subdivided, if there's 10 acres and you sell off 5, now we've got 2 new legal descriptions and 2 new parcel ID numbers. But I live in a subdivision, my lot can't be subdivided, so the PIN will not change. The PIN to a property is similar to an individual's social security number. It most closely identifies that property. And sometimes you hear it called the tax ID number. It is the number that the tax assessor uses to identify the property for tax purposes.
Very well explained. I understood that loud and clear. Good. And again, one more slide in this category. What are LTP, OTP, and CPL?
Okay, this has to do with title insurance. So an LTP is the lender's title policy. An OTP is the owner's title policy. Now, owner's policies are optional. They are not required. But the lender's title policy, no surprise, covers the lender. Everybody is covered by their policy up to the amount of their exposure. In the lender's case, that is the loan amount. So if there were to be a total failure of title where there had to be a big title claim, the lender would be reimbursed up to the loan amount. If a buyer buys an owner's policy, their exposure is the sales price. So they would be reimbursed in the amount of a complete title failure up to the sales price. So if there were a complete title failure and the buyer did not buy an owner's policy, they would lose the property because whatever the claim was, that the claimant got the property. The lender gets compensated in the amount of the loan, and the buyer gets nothing. Which is why I always counsel every buyer, I would not buy a home without an owner's title policy. We also, just a brief title insurance summary, every other kind of insurance we buy, health insurance, car insurance, homeowners insurance, they all have to be renewed, right? We pay them annually or monthly. And they all cover us for events that might happen in the future. I might get sick, I might have a car accident, my house might burn down. But title insurance is a one-time charge. An owner's policy covers us for as long as we own the property, as long as we don't change the title. You don't add somebody. Lender's title policy, if you get a new loan, if you refinance, you have to get a new title policy. But as long as you keep that loan in place, you never have to renew it. It's a one-time charge, and we're protected largely against events that have already happened that we just don't know about. So it's a little bit different from other kinds of insurance that we have. A CPL is a closing protection letter. This also is part of title insurance. Our title insurance underwriter, a CPL is issued in the event there is a mortgage loan on a finance transaction. The title insurance underwriter is basically vouching for us as the settlement agent to the lender, saying these folks are in good standing. They will hold your money in trust, in good faith, and disperse it according to your transactions. They're not going to abscond with your money. These are the good guys. So basically, it's just a letter that we generate from the title insurance underwriter to the lender saying that whoever is closing it is in good standing with the title insurance underwriter. If it's a cash transaction, there's no CPL because there is no lender. So there is no need for a CPL in that case.
Good to know. I wanted to revisit the owner's title policy for a second, because I've also heard you say that this is so important to understand that if a client refuses owner's title policy, that an attorney will often require them to sign a waiver, that they understand the risks involved. And how often do you see that happen?
You know, it's not often. Usually, if they want to decline it, the attorney talks to them and explains why that's not the best idea. I mean, if they insist, fine, but we do ask them to sign a waiver because you don't want them to come back 2 years down the road if there's a title claim and say you never offered it to them. So basically the waiver says, I was offered owner's title insurance and I declined. I want to say in regards to title insurance, I have never in 41 years seen a complete failure of title. I have seen title issues that came up, some heir came out of the woodwork or something, and the title insurance company pays them $10,000 to go away. So it's resolved that way, and the title insurance policy covers that. So I've seen that kind of thing, but a complete failure of title is possible. There's lots of things that could happen. And we've sat through a presentation about that for 2 hours of all the terrible things that can happen with regard to title, most of which I'd never even heard of, much less seen in practice, which is not to say it doesn't happen. But now settlement agents are so diligent about reviewing title. And I mean, there are always things, if the issue was not uncovered by the title examiner, we wouldn't even know that we need to clear that up, right? And that's why we have title insurance.
Right.
Because if something didn't get recorded 50 years ago, or something, there's always something that could come up. But really a title claim, I don't know that I would say it's rare. It's uncommon. I haven't seen very many in my career.
Gotcha. Well, and isn't it true that this is a new area of fraud where people are, creating a fake title and trying to sell someone's house right out from under their nose?
Correct. The digital era has brought on, there's always been fraud in everything, right? But somebody would have had to have gotten their hands on the original document and doctored it to the point that you couldn't tell it had been doctored, which is a little more difficult. You can't just white it out and change somebody's name. But in the digital age, particularly with e-recording, it's much easier to do. So yeah, and now because of that, there are additional steps that we take on the settlement end to make sure that documents are correct, that they are legitimate. But yes, the digital age has brought in a lot more opportunity, you know, as things progress, if you want to call it progress, scammers get more and more sophisticated. So there are additional ways that we would have never even thought of. You know, you watch a true crime documentary and you go, how do they even, I don't even think that way. Who even thought of that? And that's the way it is, because people are always looking for an easy way. You know, a way they can make easy money or defraud somebody, or, you know, so we always have to have that in the back of our minds. So we're looking at, that's why we have a title examination. That's why we clear title. And that's why we have owner's title insurance.
Good reminder. People can steal anything. They can steal, you know, food, or steal a car, or steal a house. So,
right.
Something to be aware of. All right, one more category today. Let's look at some acronyms associated with the lender.
Okay, and again, from our point of view, we've already discussed that our CD is the settlement statement closing disclosure. It used to be called the HUD, but in 2016, there was a big RESPA change, and it required this document. So now it's gone to 5 pages that discloses all of the charges to the borrower and how much money they have to have at closing. All of these changes are intended as consumer protection. They're intended to more accurately disclose charges to the borrower so that they're not taken advantage of. From a lender's perspective, LTV, loan to value, has to do with how much money the borrower can borrow. The lender loans money on a mortgage based on the lower of the sales price or the appraised value. So if the sales price is $100,000 and the appraisal comes back at $100,000, then the lender can loan a percentage of that. That is the loan to value ratio. If the appraisal comes back less, they're going to use that amount, which would mean the borrower has to come out of pocket for the difference. Almost what had happened universally before 2020 was, if the appraisal came back low, they renegotiated the sales price down to the appraised value. When the real estate world went crazy in 2021, you had people paying $50,000 and $100,000 above the appraised value. Everything, it was like all rules were suspended. It was just craziness. But generally, loan to value means the percentage of the appraised value or the sales price that the lender can make a mortgage loan on. And different kind of loans have different LTV requirements. You know, if it's 80%, if it's 90%, if it's 97.75%, or if it's 100%, depending on the loan type. CTC is probably the most important thing that we at the settlement office can hear from the lender. When the lender tells me the loan's approved, that's great, but have they met all of their conditions? If they have, then that loan is clear to close, which means the lender can send it from their underwriter to their closing department and generate a closing package for me. If it's approved with conditions, that does me no good because it cannot go to their closing department until it's clear to close. And so they cannot generate a closing package, so that doesn't help me. So it's good for us to understand what the lender is saying to us when they say the loan is approved. And they say, oh yeah, we're approved. Yes, I understand that, but are we clear to close? Because if we're not, approved doesn't do me any good on the closing end. From a lender's perspective, as far as qualifying for a loan, this doesn't impact us on the closing end, but it's good for us to understand. The DTI is the debt to income ratio. How much of your monthly income is taken up by debt? Because lenders have requirements of how much, you can't spend 100% of your income every month. They don't allow that, because if you run over a pine cone and get a flat tire, now you don't have the money to make your mortgage payment, so they have DTI requirements, and they vary from loan type to loan type. So just understand, and this usually now comes way before there's even a signed contract. Most sellers now won't even accept a contract if the buyer's not pre-approved. So that's already been resolved with the lender. The APR, the annual percentage rate from the lender, is not the same as your payment rate. Your payment rate is what the percentage is to calculate your payment. Your APR is the amount of money over the term of the loan that credit is going to cost you. And it factors in not only your payments over the term, 15, 30 years or whatever, they do 40-year loans now, but also what you paid up front in closing costs. All that is factored in to calculate your APR. And the lender is required to disclose that to you. So what you don't want is an APR. It's always going to be more than your payment rate, but you don't want it to be wildly more. If my payment rate is 6.5 and my APR is 6.89, that's reason, because you've got closing costs. But if my payment rate is 6.5 and my APR is 8, that means they're charging me a whole lot of closing costs. So, just keep that in mind when we're, as the borrower, being disclosed. Again, doesn't impact us as the settlement agent at all, except for I see that disclosure and I'm going, these people are getting ripped off. It's not really my place to say that, but it's good for us to know. And it's always good for us to know, because down the road, we may be the borrower. So we need to understand what these disclosures mean.
Super helpful, insightful. There's the explanation of each one. New slide. What are PMI, MIP, and PITI?
Okay. This also has to do on the lender end with what your loan to value is. If your loan to value on a conventional loan is above 80%, you are going to have PMI, private mortgage insurance. It's insurance where the lender is the covered party. Because it's a high loan to value, you have less skin in the game. So you're going to pay private mortgage insurance to compensate the lender if you default on a high loan to value loan. MIP, mortgage insurance premium, serves exactly the same purpose, but this is on an FHA loan, and it's on every loan that's FHA insured. Doesn't matter what the loan to value. If you have a low loan to value, you're probably not getting an FHA loan anyway, but it serves the same purpose. It protects the lender from borrower default if they can't make their payments. Sometimes PITI is truly, have pity on me, because my payment, including principal, interest, taxes, and insurance, is ridiculous. This is your total payment. So I have had a borrower that actually got to the table, and when they got their payment coupon, it was about $400 more than they were expecting, because all along the lender had been talking to them about their P&I payment, principal and interest, but their taxes and insurance were escrowed, and nobody ever discussed with them what their total PITI payment was. So again, PITI is our total payment. What am I totally going to have to pay every month if my taxes and insurance are escrowed by the lender?
Good explanation there. New slide. This one's a lot.
And all of this has to do with loan types and secondary market. So we know for mortgage lending purposes, HUD is the Department of Housing and Urban Development. FHA, the Federal Housing Administration, is a department of HUD. Okay, HUD is a federal department. And FHA is a government-backed, government-insured lending program. Originally, FHA was created to make housing available to underserved communities, whether it's first-time home buyers, minorities, those kind of things that, you know, might not qualify for a conventional loan for one reason or another. VA is the Veterans Administration, and VA loans are available to active duty military and veterans, and VAs are guaranteed, they're backed up to 100% by the federal government. So if you have a conventional loan, the lender is going to be more strict on the borrower and less strict on the property. If you have a government loan, FHA or VA, the lender is going to be less strict on the borrower because the government regulations are lower or more lenient, but they're going to be more strict on the property. The government regulations on a property you can buy through FHA or VA are more strict than on a conventional loan because they want to ensure that their borrower is getting a good property. So there are certain things that we know. For example, you can't just order a VA appraisal through any appraiser you want to. The VA assigns an appraiser. Okay. And there are certain things which most everybody doesn't do this anymore, but back in the 80s and 90s, it was a big deal in the vanity area of your bathroom for it to be carpeted. That was luxurious. Well, VA did not allow carpet in the bathroom. They would make you take it out. As the seller, you had to remove the carpet out of the bathroom. That kind of thing. That really is not a safety issue, but they consider it high risk because the carpet can get mildewed and now you've got mold and now you do have a health issue. So they were very strict about that. So the next two, I'm sure you've heard of. Fannie Mae, FNMA, we call it Fannie Mae, Federal National Mortgage Association. FHLMC is the Federal Home Loan Mortgage Corporation, which we refer to as Freddie Mac. So this is Fannie and Freddie, and I'm sure you've heard them referred to a lot. Fannie and Freddie are the biggest investors in mortgage-backed securities. So ultimately, the loan might be sold to Mill as the servicer, but the security is owned by Fannie or Freddie. So and the changes, the national changes in mortgage rules are set pretty much by Fannie and Freddie. They have guidelines, and other lenders kind of fall in line behind that because they want to make sure that they're meeting Fannie and Freddie guidelines so they can sell that loan later on in the secondary market. Now lenders can have more strict guidelines than Freddie and Fannie, but they don't have less strict because they want to be sure they at least meet that minimum so that that loan will be eligible for purchase in a Fannie or Freddie backed security.
So much more I know we could talk about here, but I'm watching our time here for today. We do just have one more slide. Sandy, tell us about RESPA and HELOC.
You've heard me say RESPA. RESPA is a federal act, Real Estate Protection Act. these are the rules that govern what we can do, how you can charge. These are the things that tell us what consumer protection. When documentation changed from a HUD to a CD in 2016, that was a RESPA change, because they changed the way we had to disclose fees to the buyer. And what they came up with a difference, a tolerance in how much difference there could be from what was initially disclosed to what they closed on. Because there used to be a lot of bait and switch. You know, we're disclosing our fees. Oh, wait, now we get to closing and we bump that. And RESPA made a change that doesn't allow that. So everybody in the US that's doing a mortgage loan and even a cash deal where there are charges, and there always are, right? The closing attorney is going to charge fees. They have to fall in line under RESPA guidelines. We all have to follow RESPA guidelines. So if there's a big RESPA change, and in my career, there have been two, one in 2011 and one in 2016, and I started in 1983. So they changed little things, but these were two big RESPA changes in my career. And then a HELOC is a type of loan, and we call them HELOCs, and we talk about it all the time. But a HELOC is a home equity line of credit that a borrower can obtain. We most often see them as a second mortgage, a secondary mortgage to their first mortgage, but it doesn't have to be. Somebody could have a paid off house and just get a HELOC. And basically a HELOC operates like a credit card. You're approved for up to $25,000 or whatever. And so you can draw it all out at one time and use it for something, and you pay it back, and that credit is available to you again. It's a line of credit. So if I have a $50,000 HELOC, I can get one, build myself a pool, pay it all off, and now $50,000 is available to me again. Most of them have a time frame, like it's accessible for 5 years, and after that it converts into, you know, fixed rate, fixed term. But some don't. But from the settlement perspective, a big caution we have is the obtaining a payoff statement for a HELOC. If we pay it off to zero at closing, great, just like we paid off a fixed rate first mortgage. But that does not close the account. The money is now still available. So we have to send a request to close the account as well. Otherwise, my seller just walked out the door, and now that $50,000 is still available to them on a property they no longer own. And I've just written a title policy on a title that's no longer clear because my seller went straight to the bank and took out that 50 grand. Now, I've never had that happen because most sellers are not sneaky like that, but they could. And it's our responsibility on a HELOC to not only pay it off, but to make sure the seller signs an intent letter to close it as well.
Okay, interesting. There's so much more to that than I realized. I was familiar with the term, but not all the rules around it. So good to know. That brings us to the end of our presentation for today. I am just going to pause in case there are any questions. If someone wants to post in the chat box, we'll be happy to address those. I'll also go ahead and share that we will be discussing cybersecurity next month. October is Cybersecurity Awareness Month, and we will be having our next LinkedIn Live presentation on Halloween Day. So we'll encourage you to join us and invite you back for that one.
Great job as always.
Oh, thank you.
Thanks,
Thank
Jackie.
you so much. Yes, thanks for being here. Just a quick reminder, we invite you to follow us on all the various social media platforms. Wherever you like to connect professionally, you'll find us there at Real Estate Closing Path. And again, we'd be happy to assist with any of your training needs. You can reach out to us at info, I-N-F-O, at realestateclosingpath.org. And that's the end of our presentation today. Again, thank you so much, Sandy. Thanks everyone for being here.
Thank you, guys.
Thank you.
Take care. Bye-bye.